Hello guys, this is Jay King and welcome to our COC Frisco podcast. You know what? Today we're going to be talking about the importance of an irrevocable trust. So listen in. This is some incredible information that will add value to your life.
About everything I'm going to present to you in this financial literacy setting. The majority of it is stuff you can Google, right? You just don't know what to Google. And I believe documentation beats conversation all day, every day, and twice on Saturday, right? So here's what I want you guys to start with before we jump into this. I want everyone to Google, and I can pin this to the top of the room, but I think it's important that people do it for themselves so you can see how accessible the information is, and you can read it with me. I want you to Google Article 1, Section 10 of the United States Constitution. Article 1, Section 10 of the United States Constitution. And we're going to read from that here in just a little bit. Before we get into reading what that has to say and the significance of it, here's what the difference is between a grantor trust and which is a revocable trust. Most of the trusts that are produced out here today by attorneys and CPAs are going to be grantor trust. Most of them are referred to as living trust. We're all familiar with that term. A living trust is not a trust contract. It is a trust agreement. And if you guys pulled up Article 1, Section 10 of the United States Constitution, we are going to look at why that is significant. But before we take a look at Article 1, Section 10, I want you to understand a revocable trust and an irrevocable trust. When Yawasap says once you set up an irrevocable trust, it's irrevocable only to the creator. So the person who is the creator in that trust contract can't shut this thing down. Only the trustees have the ability to shut it down, to put assets in, to put assets out. It is solely on the trustees to control this thing. So you hear about people hiring trustees to manage their assets. That is not how the elite function. What they will do is they will have a family member be the creator of the trust so that you can be the trustee of your own trust. You have full control and authority. So let's do this. Let's start with the definition of a trust, and then we're going to look at Article 1, Section 10 and why that is so critical and how much information they gave us. I believe Article 1, Section 10 is the most valuable part of our United States Constitution. They give us more information in that one little paragraph. I believe it's like 3 or 4 sentences that is pertinent to us than they give us anywhere else in the entire Constitution, in my opinion. So the definition of a trust. A trust is a 3-party contract in which one can create a binding, inviolate entity. The creator is able to specify the terms, the provisions, and who the other parties are. So it's a 3-party contract. Who are those 3 parties? Yawasap just mentioned them. You have the creator, you have the trustees, and you have the beneficiary, right? Those 3 parties make up a trust contract. Now, if they're 3 separate, distinct parties, that contract makes a separate legal taxable entity. By IRS definition, it's a separate legal taxable person. It's somebody completely separate from you, though you still control the assets thereof. Now, when I mentioned a living trust or a grantor trust, what they will have the person do is they'll have them be the creator, have them be the trustee, and they'll have their loved ones, a kid or someone, be the beneficiaries. That is still there's 3 positions in that contract, but there's only 2 parties. Because one person is the creator, one person is the trustee. You can't have three distinct parties when one person is holding 2 positions. That creates a trust agreement. Now, here's why that's significant. Let's say you have someone who has a grantor trust, a living trust that an attorney has put together for them, and they hold those 2 positions. They go out, they get in an accident, they accidentally kill somebody, and the family of the loved one that's perished is upset, and they want to sue. They want to go to court, right? They go to court. The individual's like, well, I don't have anything. I don't own anything. Okay, well, they somehow find out you have a trust. They're going to say, Your Honor, we want the assets in the trust. And the judge is going to say, let me see the trust contract. If it is a living trust, it's not a trust contract. It's a trust agreement, which means it is an alter ego. It is still you. So everything in your trust that you thought was protected, all your assets are not protected, and that lawsuit can take anything and everything from you. Now, same scenario with a proper trust contract. A proper trust contract, you go into court, they say, look, we want to sue. Okay, he doesn't own anything. Well, we want to sue for the assets in the trust. The judge is going to look at that and say, this is a true trust contract. So this is a separate legal entity. I can't give you that because Roger doesn't own it. He might control it, but he doesn't own it. There is no asset protection in a grantor trust, in a living trust. And this is what people don't understand. About 95% of the trusts that are produced today for families are living trusts. They're grantor trusts. They're good for probate. What that means is all of the assets, once the creator dies, all of the assets in that trust will definitely go to the beneficiaries the way that you desire to go there. It's not going to go through the probate process, which is beneficial, but there's still no asset protection for it while you're alive. So we need to take care of the thing. We work too hard to acquire things in this life to put them at risk of losing them simply because we weren't told all of the information, right? So that's the significance of a trust. I'm gonna read the definition again. A trust is a three-party contract in which one can create a binding, inviolate entity. If you do it right, it's legally binding, and that's what I'm going to show you, and it's inviolate. You can't violate it. That's in the very definition. A binding, inviolate entity. The creator is able to specify the terms, provisions, and who the other parties are. So let's go look at Article 1, Section 10, which I had you guys pull up on Google, because I want everybody to read stuff with me. I don't want you to listen to my voice. I want you to read it along with me and understand that I ain't making this stuff up. It's right there in the Constitution, and they're telling you things that you need to know. So I'm going to read all of this so you guys can understand, there's three topics that they're covering in Article 1, Section 10. It starts with no state shall enter into any treaty or alliance or confederation. Okay, so no state can enter into a treaty with another country. That's for the president to do, right? Then it goes on to say you can't grant letters of marque or reprisal, and you cannot coin money. Now, hear this. The states can't make money. They cannot emit bills of credit. They cannot make anything but gold and silver coin a tender in payment of debts. That's going to be our next conversation. I told you, Article 1, Section 10 is the most valuable piece of information we have in the Constitution. And what we're talking about now, contracts, and what it said right there about the states can't make money and they can't use anything but gold and silver as tender in payment of debts. Now, after that, it says they cannot pass any bill of attainder or ex post facto law or any law impairing the obligations of contracts. That's the part I wanted you to see. So we're going to focus on that one part. The United States Constitution in Article 1, Section 10 says, in part, no state shall pass any law impairing the obligations of contracts. So when you put together a trust, you're putting together something that the people who make the law cannot pass a law that can mess with it. So I want to give you another example of why the contract is so important. And this is a court case called Hotchkiss versus Northland Petroleum. And I want you to hear this. And I'm going to give you a real live example of this because we've all seen this in real life. It says, courts, however, must enforce contracts as made, not make new ones for the parties, no matter how unreasonable the terms may appear. So what we have is the Constitution telling us that the people who make the law, the states, cannot pass a law that can impair the obligations of contracts. And then we have the courts telling us that courts must enforce contracts as made and not make new ones for the parties, no matter how unreasonable the terms may appear. So check this out. If Sap and I were going to go into a contract we're going to contract on some business, right? And for whatever reason, I agreed that he's going to get 98% of the profit and I'm going to get 2. That's legally binding. It's legally, I don't care if we went to a restaurant, wrote it on a napkin. It's legally binding if we both put our signature to it. It's a contract. If you guys have ever watched any of the judge shows, when they come in with their dispute, the judge will listen to one side of the dispute, the judge will listen to the other side of the dispute, and then the first thing out of the judge's mouth is what? Do you have a contract? And there's a reason for that. That judge is on television. They have to enforce contracts as written. They cannot change them. And the Constitution says that the lawmakers can't make a law that can mess with a contract. So for all intents and purposes, when you put together a trust contract, you're basically creating law. If the lawmakers can't mess with it and the people who have to enforce the law must enforce it, for all intents and purposes, it's creating law, right? Now, I had Yalasap start out with his experience in structuring trusts, and he mentioned something about after having the trust notarized, that he would take it to the county recorder's office and record it. And what that does is it tells you that that is a statutory trust. It is registered under that state, in that county, under some judge or county recorder's office. There are different levels of jurisdiction. So we talked about this a little bit in that room the other day. I want to make it real clear today that a contract all by itself, according to the Constitution and legal precedents, a contract all by itself should be bulletproof, but it's not. And here's why it's not. We have a whole bunch of judges all across this country who legislate from the bench, meaning they don't follow the Constitution, they don't follow Supreme Court precedents, and they make stuff up as they go. It happens all the time. So what happens is you got to come out of that jurisdiction. Most people don't understand that there's 3 different jurisdictions of law that we can operate in America. And here's what they are. Admiralty law. That's military. Nobody wants to operate there because you don't have any rights. The second is statutory law. That's state law, which is what all of us have been taught. We got to operate within the arena, the realm of the state, right? If you live in a state, you got to operate under state law. That's not true. The third is common law. And when I say common law, I'm not talking common law like common law marriages. That changes from state to state. So clearly that's statutory. What I'm talking about is English common law. This whole country was founded under English common law, except for Louisiana, which was initially owned by the French. And today, the true law of the land of Louisiana is still Napoleonic law. But for the rest of the United States, we are a common law country, and you can choose to put a trust into that jurisdiction, which means you now operate above the state, which is significant because you don't have to register your trust anywhere. You don't have to record your trust anywhere. And I want y'all to think like wealthy people think. If I have a trust document and I'm somebody who's got a couple $100 million, why would I register that somewhere so the whole world can look at it and know who my beneficiaries are? That's the kind of stuff to get your kids kidnapped, right? They operate privately. They're not about to have any entity they got to register and let people know who their beneficiaries are, because that's going to get somebody hurt when you got that kind of money. You just don't do it. But I want you to hear what the Supreme Court says about this particular trust once it's created. It says, and this is a court case, Supreme Court case called Crocker versus McClay. It says a trust contract consisting of a U.S. constitutional right of contract. I'm going to pause right there. It says a U.S. constitutional right of contract. What was the Constitution written under? The Constitution was written under English common law. There was no statutory law. There was no states. So I want to read that again. A trust organization consisting of a U.S. constitutional right of contract cannot be abridged. Cannot be abridged is what the definition said. It's inviolate. You can't penetrate it. So it says it cannot be abridged. Check this out. The agreement, when executed, becomes a federal organization and not under any of the laws passed by any of the several legislators. It becomes a federal organization. So what does it do? It takes you out of that jurisdiction where one single judge can violate law. And here's why that's significant. When you go to the federal level, if you don't agree with the decision, there's always the appellate court, where there's at least 3 different judges sitting on the bench holding each other accountable to the law. You don't get that at the state level. You don't get it at the state level, which is why you have so many rogue judges at the state level, and not everything is going to reach an appeals court at the state level. So coming out of that jurisdiction is critical, and this is how you actually make that trust contract bulletproof. You put it in the proper jurisdiction of law. The 2 most powerful tools we have in America is a contract and the proper jurisdiction of law, because it puts authority back in your hands. Now, let me give you a couple court cases to support what I'm saying, because that case says a trust organization consisting of a U.S. constitutional right of contract cannot be abridged. It doesn't say common law, right? I'm telling you about English common law. So let me give you a couple more cases to let you know that that's exactly what that case is talking about. This is from Elliott versus Freeman and Crocker versus Malloy. It says a business trust is a common law entity formed by contract and thus is not subject to the same types of state regulations as a corporation. There's your jurisdictional delineation right there. It is a common law entity formed by contract. It's not, we don't get permission from the state. We don't need permission from the state. And so we're not subject to the same types of regulations as a corporation. We call the shots. Next case, Ashworth versus Hagen Estates. One of the main objectives of a trust contract is to obtain most of the advantages of corporations, but with freedom from the burdens, restrictions, and regulations generally imposed upon them. Read that again. One of the main objectives of a trust contract is to obtain most of the advantages of corporations without the burdens, restrictions, and regulations. Last case, and this is Wagner Oil versus Marlowe, and there's several different sightings for this precedent. It says a business trust may be organized to engage in any business in which individuals or corporations may lawfully engage. So, when we're talking about financial literacy, we have to understand that it's not so much what we earn. You know, if you're an entrepreneur, if you got an entrepreneurial mindset, you'll figure out a way to make money. It's about how to protect that money, how to protect your assets, how to keep the IRS out of your pocket. All of those things that we hear these billionaires and these multinational corporations, we hear about them not paying taxes all the time. It's because their business is structured properly. Because a trust can do some things that a corporation and a person cannot do. So this part of what we're going to talk about, the financial literacy, is probably a little bit advanced for most of those who will hear this recording, but it is something you want to prepare for. Everybody needs to have a business, and once that business becomes profitable, you need to structure it so you can keep your money and you can keep the government out of your hair. Now, having said that, whether you have a business or not, if you have anything that you want to protect, if you have, let's say you got an inheritance or life insurance, right? Somebody left you a couple $100,000 in life insurance. The last place you want that is in your bank account. The last place you want that is in your bank account. The example I gave earlier, if you get in a car wreck and they want to sue, you got a couple $100,000 sitting in your bank account, you just became a target. You're a target. Your home. You don't want to have your home in your name. Anything, if you have assets that you truly value, everybody at some point in time is going to need to have a trust, because anything you have in your name is a liability. Nelson Rockefeller said the key to success is to own nothing but control everything. Robert Kiyosaki says the difference between rich people and poor people is poor people want to own things, rich people don't want to own anything. What they're not telling you is the only way to accomplish what they told you in that little breadcrumb scenario they gave you is the only way to do that. The only way to control things without ownership is to put it in a trust, because when you're the trustee, you don't have the liabilities of ownership. Your assets can become a liability if they're not protected. If you got a life insurance settlement and you got a couple $100,000, from a loved one, and you go out and get in a car accident or any kind of lawsuit, that asset you just received is now a liability, because when an attorney sees you got it and it's in your name, they're coming after it. Everybody needs a trust if you have anything that you want to protect. As you're building your business, as you're moving towards accumulating wealth, you need to structure that business through proper trust structure to protect the business, to protect its assets, and keep the IRS out of your hair. I'm going to give you guys two more things real quick. One from the IRS, because we're talking about state law, right? It says it operates above state law. It's not subject to any of the laws passed by any of the several legislatures. I want you to see, according to the IRS and according to the federal government, that this contract will determine what's going on. When I tell you, for all intents and purposes, it is creating law, I want you to hear me, and I want you to believe me. So this is in Title 26 of the Internal Revenue Code. It says, according to Title 26 and Section 21, gross income means all income from whatever source derived, including but not limited to the following items: income from an interest in an estate or trust. Now, hear this next sentence. IRS states fiduciary accounting income is the amount of income determined under the local law or the specific terms of the governing instrument. Now, the governing instrument is your trust document. That is your contract. So I'm going to read that sentence again, and I'm going to put the word contract in there. IRS states that fiduciary accounting income is the amount of income determined under the local law or under your contract. Is that or is that not the IRS putting your contract on par with the local law? But it gets deeper. In Section 643 of Title 26 of the Internal Revenue Code, it says this: income is determined under the terms of the governing instrument, period. It doesn't say anything else. It doesn't mention local law, doesn't mention anything else. We determine what is income. We determine what's assets. We determine what is expenses, because it's all done by contract, and they can't mess with the contract. Now, that's the IRS. I'm going to take you one more place, and then I'm going to take some questions, and we'll wrap it up for tonight. The Uniform Trust Code. This is a statute handed down by the federal government to the states. The Uniform Trust Code says this. This is the opening sentence in the Uniform Trust Code. Article 1, general provisions and definitions, general comments, and then it goes in. First paragraph, first sentence says this. The Uniform Trust Code is primarily a default statute. Most of the code's provisions can be overridden in the terms of the trust. So let me back up, and I'm going to read that in layman's terms. The Uniform Trust Code is primarily a default statute. Most of what we're going to write to you can be overridden in your contract. Your contract will override this statute that is coming from the federal government. Last place I'm going to read in the Uniform Trust Code, because I want you guys to understand the value of a contract. This is why I took you to the Constitution first, where they said they can't pass a law that can mess with a contract. They did that way back in the 1700s because they already knew how they were going to operate, and they don't pass laws that affect them. So I want you to hear this clearly. It says, however, the Uniform Trust Code does not try to incorporate detailed rules for every conceivable kind of trust, nor does it incorporate all of the kind of trusts that there are. It does not contain statutory rules, state rules, that are already governing trusts in many jurisdictions and that are working just fine. It does not displace, for example, the Uniform Prudent Investor Act or the Uniform Custodial Trust Act. What the Uniform Trust Code contains is a set of basic default rules that fairly, consistently, and clearly govern voluntary trust. Now, here's the kicker. Here's the last sentence. It is a default statute for the most part. because the terms of the trust instrument will govern, even if inconsistent with statutory rule. I'm going to read that one more time. It is a default statute for the most part, because the terms of a trust instrument or the trust contract will govern, even if inconsistent with statutory rule. That's your IRS and your federal government telling you your contract will outweigh what they say. Proper structure dictates function. Remember that. Structure dictates function. And when you structure your business, your family, your charitable giving, all of that, when you structure it properly, it dictates how much of your money you get to keep and how much they take from you. Be it through taxes, lawsuits, or creditors, or whatever the case may be. Anything you own can be taxed to you and taken from you. You don't want to own anything you want to control things. Don't want to own anything you want to control things. Don't want to own anything you want to control things.